Welcome. My name is Justin Murray. I'm a professor here and the co-director of the Criminal Justice Institute, part of the Impact Center here at New York Law School, and we are delighted to have Jeff Deskovic with us as a guest today. Mr. Deskovic is an exoneree who, at the age of 17, was sentenced to life in prison for a terrible crime that he did not commit: the rape and murder of a 15-year-old girl who was in his high school class. Mr. Deskovic remained behind bars for 16 years before he was finally exonerated following a protracted post-conviction investigation and legal fight, which he's going to tell us a little bit about today. Since his release, Mr. Deskovic has earned a law degree from Pace Law School just across town. And I believe you've also more recently gotten a master's degree at John Jay's, is that right?
You're right. You got the order wrong, though. I got the master's degree first, and then I got the law degree.
Sorry about that.
No worries, it's fine.
Mr. Deskovic also brought a successful civil lawsuit against those responsible for wrongfully convicting him. And then he used a portion of the compensation that he received from that civil suit to launch the Deskovic Foundation, a nonprofit organization dedicated to the exoneration of the wrongfully convicted, their recovery, and reform of the system that allows these miscarriages of justice to take place. The Deskovic Foundation has freed 7 people and currently has 11 active cases, in addition to providing assistance in other cases. Welcome, and thank you for being with us, Mr. Deskovic.
Please call me Jeff, but I'm happy to be here.
Okay, I will call you Jeff. So Jeff, maybe you could just start by giving us a little bit of background about what this crime was for which you were wrongfully convicted, and how you got tangled up in it. Right, I mean, mistakenly tangled up in it. Of course.
I know what you meant. Yeah.
But what was it about the police investigation that kind of brought them to your doorstep initially?
There were 3 factors. Firstly, I was quiet and to myself in the high school. I wasn't with the in crowd, and some of those students, when questioned by the police, they told them that, you know, they might want to speak to me because I didn't quite fit in. I guess the theory is that people that don't fit in and are quiet commit heinous crimes. I guess that's the underlying theory. Police also cited, they interpreted by being emotional at the victim having been murdered. So her name was Angela Correa. She was a immigrant from Colombia. She had been in the country for about 1.5 years. She was a classmate at Peekskill High School. Two of my classes as a freshman, one as a sophomore. I mean, I knew her name. She knew mine. That was really the extent of it. I was like a sensitive teenager. It was really my first brush with death. And so I had this emotional reaction, but the cops thought that was suspicious, that was some kind of outward manifestation that I was sorry for what I had done. A reinforcing factor is that the Peekskill police weren't really all that experienced in investigating homicides. So they got a psychological profile from the NYPD, which purported to have the psychological characteristics of the actual perpetrator. And I had the misfortune of matching those characteristics. So it was a type of reinforcing factor.
Yeah, that's a type of junk science I haven't previously heard about before. Once they suspected that you were involved, they eventually were able to get additional evidence, in particular a confession. And what was the way that they were able to wring a confession out of you?
Sure. So, well, I just want to give us just a tad of context. So for about there was a 6 weeks run up to that. And in which half the time they talked to me as if I was a suspect, and the other half the time they pretend like they needed my help to solve the crime. So meaning they start out questioning me and Jeff as a suspect, but then when they push too hard, I'd become frightened and I'd want to get the heck away from them. That's when Jeff as this junior detective helper theme was what they ran out. They did and what intersected with that was that prior to being a teenager, the career that I wanted to have when I grew up was to be a cop. So that intersected with that, and, they helped egg it along. Kids won't talk freely around us. They will around you. Stop in from time to time. They'd ask me opinion questions. They congratulate me that my opinions were correct. Came from a single parent household, and that intersected with the good cop, bad cop technique, in which when the one officer is really aggressive, the other pretends to be a friend that's opposed to what's going on, but somehow can't intervene. And I began to, coming from a single parent household, that intersected with that, because I began to look up to the good cop as a father figure. So eventually they got me to agree to take a lie detector test by telling me some new information had come into the police file, and they wanted to share that. But I guess much like an intelligence officer, I'd have to pass a polygraph first. So the next day, instead of going to Peekskill High School, where I heard the rumor mill that the test was being given, I instead went to the police station. So my mother and grandmother thought I was in school, so they didn't call around anywhere looking for me. And they drove me across county lines, 40 minutes away by car. Now I don't know where I'm at. I'm totally dependent on the cops. The polygraphist was a Putnam County Sheriff's investigator, but he's dressed like a civilian. He never identified himself as a police officer, never read me my rights. So I never had a clue he was law enforcement. They didn't give me anything to eat the entire time I was there. Had no attorney present. They gave me a brochure.
I gathered they loaded you up with coffee, but no food all day, right?
That's exactly right. I was just coming to that. Yes, exactly. Yeah, to get me nervous, which is, they're trying to rig the polygraph test result in doing that, because the premise of the polygraph is that when you tell a lie, you'll become nervous, and that will result in an increased pulse rate. And it's that pulse rate which is measured by the machine. But the issue is that other factors could result in an increased pulse rate, such as fear and caffeine. So then he launches into his third degree tactics, and he invades my personal space. He raises his voice at me. He keeps asking me the same questions over and over again. And I'm becoming more and more frightened. And I'm not used to talking to adult males, much less ones that are conducting themselves like that. I'm 16 years old. I'm maybe 140, 150 pounds. And he kept that up for 6.5 to 7 hours. And eventually he said, "What do you mean you didn't do it? You just told me through the test result that you did. We just want you to verbally confirm it." That's when the cop who came in the room, who was pretending to be my friend, and he said, "Look, I've been holding off the other officers. They're going to harm you. I can't do that any longer. You have to help yourself. Look, just tell them what they want to hear. You can go home afterwards. You're not going to be arrested." So being young, naive, frightened, 16 years old, I wasn't thinking about the long term. I was only concerned with my safety in the moment. And I was in fear of my life. The fact that I didn't know where I was, that no one else knew where I was either, loomed quite large in my mind. I was overwhelmed emotionally and psychologically. There was a possibility of harm had been thrown in the air, this false life preserver. So it all culminated into my making a decision to make up a story based on the information that they gave me in that 6.5 to 7 hour interrogation, in the 6 weeks run up to it. By the time it was all said and done, I collapsed on the floor into a fetal position. I was crying uncontrollably. Needless to say, I was arrested. I was charged with a murder and rape.
Yeah, and so another very important piece of evidence was the physical. I mean, and not against you, but potentially in your favor, right? Was the physical evidence, which didn't match up to you. Can you talk a little bit about that?
Yeah, absolutely. So there was before the trial started. And by the way, the police, Peekskill police, were told by a prosecutor not to arrest me because they wanted to arrest me. They had no evidence. The prosecutor told them, "Don't arrest him. Wait for the DNA test results to come in from the FBI lab." But they weren't content with that. And hence this whole get the confession scheme vis-a-vis this polygraph. So with that in mind, after the arrest, but prior to the trial, the DNA test results come in from the lab, FBI lab. Semen found in and around the victim don't match me, but the prosecutor got this medical examiner to commit fraud and claim 6 months after doing an autopsy that he forgot to document medical evidence that he said showed the victim had been promiscuous and sleeping around. And that was a lie. The victims had been living a very sheltered life. She never went anywhere unless her older sister or parents were with her, as I understand it. And the family was not coming to court, so they had no idea that her reputation was being trashed in the courtroom. They he took his lie a step further, and by the way, that lie opened the door for the prosecutor to argue that it didn't matter, that the semen didn't come from me, that it could have been from yet another person that she slept with prior to being murdered and raped by me. Taking it a step further, they named another student at the Peekskill High School that they claimed had slept with the victim, but they never set the proper evidentiary foundation. So they never had a DNA test performed on him to prove that. They didn't even call him as a witness. They just made the unsupported argument to the jury. So that's that piece of evidence, but I just need like a minute or two here. I'm trying to be concise. All right. So hairs found on the body, in and around the body, were determined to be of Negroid and Mongoloid origin. And I'll state the obvious. I'm pretty much as white as you can get. Okay. So that didn't match me. But again, the prosecutor resorted to arguing by impermissible inference rather than trying to get actual evidence. So he claimed that this hair must have come from the Vietnamese medical examiner and his African-American assistant. So the last piece of evidence that I'll mention, and I usually don't get a chance to discuss this, but I will here, is that the victim's clothes, including her bra, were admitted into evidence. And that intersected with one of the statements in my coerced false confession, in which I had said that I ripped her bra off. The jury asked to see the bra. And that was a brief bright spot for the defense, because as my lawyer told me, he said, they're thinking the way I want them to think. Some bras cannot be physically pulled off of somebody. You can't rip them off. So it was at that point when they asked to see the bra, that's when the trial judge announced to the courtroom, he said, well, the victim's clothes, including that bra, had been left in the courtroom over the weekend, and apparently the custodians, the orderlies, thought it was garbage, and so they threw it out. And he allowed a photograph in which he said you can almost see the bra. He allowed that to be substituted for the actual bra. Now, the last thing I'll say for the context of this, in terms of the DNA, now my trial lawyer compounded it because he never tried to discredit the medical examiner. He literally never asked him a single question. He never explained to the jury the significance of the DNA not matching me. He never used that to argue that proved the confession was coerced or false. And lastly, the defense was not able to ask that other youth about whom it was falsely being said that he had slept with the victim. We were never, ever able to ask him for a DNA sample or call him as a witness because of a conflict of interest, in that he was represented by another member of Westchester County Legal Aid, and specifically by the lawyer who was supposed to be supervising him on my case.
Mm-hmm. Jeff, can you tell us what did your defense lawyer do for you at trial? What was his theory? What was his approach? He or she?
It was a he. No, it was a he. Yeah, I really don't think he had. I really don't think he had a theory. I mean, I'm going to explain what omissions he did, and I'll let everybody figure out their own conclusions. So he never interviewed or called as a witness my alibi. I was actually playing wiffle ball with a friend in Peekskill when this happened. Another thing is he rarely met with me. When he did meet with me, and I tried to explain to him that I was innocent, what happened in the interrogation room, he was always shutting me up. One time he told me he didn't care if I was guilty or innocent. In terms of the confession, at times he argued to the jury that the confession never happened. At other times he argued that it happened but was coerced. At still other times he was arguing that it happened but it was false. So taking that type of scattershot approach had to leave him standing there with like next to no credibility with the jury. I told you already about his deficiency in cross-examination. My interrogation was not video or audio tape. There was no signed confession. So it was just the cop's word for it. So when they came to court, they were able to lie by omission. They left the threat and false promise out of their story. And my lawyer wouldn't allow me to testify at the pretrial hearing, which was been the only way those facts could have been considered. He wouldn't allow me to testify at trial either. He said it wasn't his job to prove I was innocent. It was up to the prosecutor to prove I was guilty, which, although that's a legal principle, I'm going to say right now, especially for this audience, that's an extremely naive way of practicing law. In reality, if your client's charged with a crime that he or she didn't commit, you have to try to prove they're innocent, or they run a risk of possibly being wrongfully convicted. Particularly in a confession case, there's an 80% conviction rate. So you have to answer that confession. You have to explain that confession. You have to put your client on. You have to prove it's false, as many little parts as you can pick and show, and then bring it all together in your closing argument. But he didn't do any of that.
That's absolutely right. So I'm a former public defender, and we were always taught, yes, you emphasize to the jury or to the judge that you don't have the burden legally of proving innocence, but then you go on immediately to do every darn thing you can to prove innocence. So, a quote I was told was that if a jury is going to let you off on a serious crime, there needs to be a palpable aura of innocence, right? Innocence has to be in the air. There just has to be this sense in the room that something terrible is going to happen if the person is convicted. And if the jury doesn't have that palpable sense, there's a real risk of a wrongful conviction happening. Can you tell us a little bit about what it was like to be incarcerated, and to be incarcerated for 16 years for something that you didn't commit? And the reason I want to touch on this, I think we often jump over this part in law school, right? In our 1L substantive criminal law class, we talk about carve up the crime into the elements, and is the person guilty? How are they culpable? But we kind of skip what is punishment like for the people who experience it.
Completely agree with you. And these cases don't happen in a vacuum. There are real life consequences. So I completely agree with your rationale, and I'm glad you've asked me this question. I would describe prison as a nonstop obstacle course featuring the guards, the prisoners, and the civilians, all as obstacles to the ultimate goal, which is try to overturn the conviction, regain your and regain your freedom. There were 3 or 4 stabbings or cuttings every day. There was plenty of violence that didn't involve weapons. There was gang activity. So I had to always be on a heightened sense of alert. I had a metaphorical bullseye on my back because I was been wrongfully convicted of a sex offense, which is a vigilante mentality, which people convicted of sex offenses. The food was terrible there. They had a system of maintaining order in the prison, which involved if you were found guilty of having broken a prison rule, they would keep you in the cell 23 hours a day. They'd send you less food. Sometimes the food would be 3 or 4 days old. You could take 2 showers one week and 3 the next, rather than being able to shower daily. Their idea of complying with court mandated 1 hour a day recreation would put you in a small caged area with maybe a pull-up bar in it if you were lucky. You would not be able to use the phone on that status. You couldn't go to the commissary, which is their way of going to the store. So many times there were it was more times than I care to remember that I was beat up. I mean, let's be real. I was 17 years old, 150 pounds. What am I going to do in a fist fight or something involving weapons against a fully formed adult, many of whom were guilty of committing serious crimes? So at times I was beat up. One time I nearly lost my life, but it wasn't just this is just the external realities. But another element to that is I had to keep fighting off feelings of hopelessness, helplessness, thoughts of giving up, suicidal ideation. Half the time I couldn't believe I was actually there, because the odds of every single one of the factors happening that led and culminated into the wrongful conviction, the odds of any one of them happening seemed to be astronomical, much likely that all those things would happen. So half the time I couldn't quite believe my senses. So, and every time I lost an appeal, which, I lost 7 appeals, every time I lost an appeal, I mean, the crash back down to earth would be very loud and hard. I mean, I used to research the draft briefs that were sent to me, prior to being submitted, and I would look up the cases. I would pretend like if I was a judge, and I was looking up the authorities cited and trying to determine the strength of the arguments that my freedom was now being tied to. And it always seemed to me that I had the better argument. and I knew that factually I was innocent. So, how do you not hope? So to me, I wasn't doing 15 to life. I thought I was doing a year or two until the next proceeding was going to happen, which I was sure I was going to win because I was innocent and I believed in the system, and so you start to soar and you get up and your morale is there. But every time I lost, I mean, the crash back down to earth was loud and hard. It was like being wrongfully convicted all over again.
7 times, wow.
7 times. And I'll add, after that, I wrote letters for 4 years looking for help because, as you know, when your appeals are exhausted, there's only two ways back in the court after that. One of them is if there's a retroactive change in the law that's going to apply backwards, but that's wait for Haley's comment on that one. And the other way is if you can find some previously unknown evidence of innocence that would probably have resulted in a different verdict. So because I was locked up and I wasn't personally reinvestigating anything from behind the prison wall, and because my family didn't have any money to hire an attorney or an investigator, my legal work, will be artsy about that term now, was writing letters, looking for someone to take my case on pro bono. And so I wrote letters for 4 years, rarely getting a response other than the occasional no. And then I went to the parole board where, because I maintained my innocence and I, rather than expressing remorse and taking responsibility, showing insight into my behavior, I was denied parole, despite their decision noting my excellent educational record, my good disciplinary record, and letters of support, including from a prison employee. And they, that was a factor, and they cite nature of the crime, which is an absurdity because that's something that's never going to change. The charges are already known at the time that taken into account by the judge who fashions the sentence, and their parole board, in reality, they're supposed to be there to assess rehabilitation and whether, if released, the applicant would remain at liberty and live without breaking the law. But instead, with this preoccupation with, if someone's there for a violent crime, just citing that, I mean, it flies in the face of rehabilitation. So at that point, I thought I was going to die in prison. So altogether, I did 16 years. I went to the parole board. I did 15. I got ordered to do another 2. And fortunately for me, I only did another 1 before I was exonerated.
Yeah, and can you tell us what changed in your case? What changed that led, right, that made it so that rather than losing another appeal or losing another post-conviction or habeas proceeding, losing another round at the parole board, you actually wound up being released?
Yeah, so these confluence of 3 events lined up just right that once accentuate. So I got the Innocence Project to represent me, which was a minor miracle in and of itself. I mean, I wrote a letter in care of a publishing company to a book author, but instead they sent it to an investigator, not the book author. And once I proved to her that the DNA didn't match me, she was instantly convinced of my innocence. And she connected me to the Innocence Project. So she suggested I write them. She lobbied them. She got other respected legal entities to also lobby them. Then I got lucky that one of the intake workers, who's a new attorney as well, Maggie Taylor, she was working in intake. She wasn't an attorney then, but the Innocence Project didn't want to take my case because the DNA excluded me. So their model of taking cases was, let's just take a case where we can just test the evidence. If it doesn't match, we just file this post-conviction procedure under the newly discovered evidence argument, which was not available because you might say that I was excluded a little too soon for my own good. It wouldn't have constituted something new.
Can I just amplify or clarify
Please.
this point for the audience? So my understanding, and correct me if I'm wrong, of what you just said is that the way that the Innocence Project usually likes to intervene in a case is where there is potential DNA evidence, but it has not yet been tested, right? So that they can then come in, do the testing, and then say, wow, well, now that the DNA exonerated the person, that puts all the other supposedly incriminating evidence in a whole new light. But because you had already been arguably exonerated by the original testing, and the prosecutor had developed a theory to explain it away, and the jury had accepted that theory, right? Does that fairly explain kind of why?
100%. Yes, yes, that was a very succinct and clear way of putting it. Yes, I agree with that completely. So because of that pre-existing exclusion, they didn't want to take my case again. Like I wrote them back in 93 when they first got started, and they didn't take it because of that pre-existing exclusion. So fast forwarding 15 years, I'm applying again because of the investigator. They again don't want to take it, but this case management intake person represented my case to them twice, finally pushing me across the third time using an idea that I had suggested to her, asking her, well, what about the DNA data bank? And so they accepted it on that theory that if doing the data bank could have been this is something new that you didn't know, as you explained. So getting the representation was the first key, first of three. Second thing is that the former Westchester District Attorney, Janine Pirro, who was not the DA when I was convicted, but became the DA prior to my first appeal being decided. So she was the stopper. She's the one who fought me in all 7 of the appeals. She's the one who blocked me several times from getting further testing. She's the one that got me dismissed from federal court when my paperwork arrived 4 days late. A lateness.
This is the Fox News anchor.
This is the Fox. Yes, exactly. This bastion of civil rights, to hear her tell it now. Yes. So my paperwork arrived in federal court 4 days late because the court clerk gave my lawyer the wrong information. So her office urged the court to just dismiss my case, which is what happened. And then the next 3 courts, which included Judge Sotomayor, all signed off on that decision. They were all fine with that. So Pirro left office is my point. And the third thing is we got lucky in that when we took that crime scene DNA evidence, which already excluded me, and put it into the data bank, it matched the actual perpetrator, whose DNA was only in that data bank because left free while I was doing time for his crime. He remained out in the community in Peekskill for 3.5 more years. And at the culmination of that 3.5 years, he killed a second victim, Patricia Morrison, who was a school teacher and had 2 children. He got caught for that. And that resulted in his DNA being put in the data bank so that when I eventually got the testing, it matched him. So on September 22nd, 2006, my conviction was overturned. I was released. I reported back to court November 2nd, 2006, at which point all charges were dismissed against me on actual innocence grounds, whereas he was arrested and convicted and sentenced for the crime.
And at that point, after they've made the match to the real perpetrator, the prosecutor is not coming up in court, coming up with fancy theories about the victim being promiscuous and the semen being from consensual sex, right? I mean, they've matched.
No, they abandoned all of those arguments. Yeah, and look, I had the actual perpetrator at the time of the crime, just for context. The victim was 15, I was 16. The actual perpetrator was 29 years old. He worked in Peekskill Beer and Soda up on Division Street near the monument. Some of my Peekskillians are with me here. They know what that means. But he was 29 years old, and I had never saw him a day in my life. And so, there was no way for them to claim that we somehow worked together. I mean, that would have been like absurd on its face.
Yeah. Can you tell us a little bit about what life has been like since you were finally released from prison, and and touch on whatever aspect you like, your experience in law school, what brought you to law school, creating this foundation that you're now running. I'll ask you specifically in a little while about the work that you're doing around wrongful convictions, but just if you could tell us more generally about readjusting, re-entering society.
Yeah, sure. I'll just focus on the reintegrative aspect, and I'll let you throw me a question on foundation advocacy. I do want to do a question on law school, but I'd like you to come from a separate question on that.
Okay.
So in terms of reintegration, so it's normal when someone's been wrongfully imprisoned for them to have psychological after effects, post-traumatic stress disorder, panic attacks, anxiety, feeling of having been frozen in time. So I was released at 32. For a long time, I felt like I was 17 because that was the age that I was last free, feeling of processing things at a slower speed. Technology was different. Internet, GPS, cell phones, those things hadn't been created. Culture was totally different, and cities and towns, including Peekskill, looked just similar enough, but just dissimilar enough. So I felt like I was an alternative universe. So cumulatively, it felt like I was in this parallel world. There was a stigma attached. So nobody was really questioning my innocence for the most part, for the overwhelming most part, because the actual perpetrator was arrested, convicted. There was a report issued by the Westchester DA's office, which did a breakdown of a lot of the failures throughout the process that culminated into that result. So for the most part, no one was questioning my innocence. But what was being questioned was, well, you were in prison for 16 years wrongfully. Yes. But you were there for 16 years. So how much of that rubbed off on you? Is it safe to be alone someplace with you? So that has proven to be an obstacle for me with respect to personal relationships. New York State does have compensation, and I was able to sue and receive some, and we'll tied back to something you said before, but that's a process, and that took 5 years for me. And so, I was just released with nothing. And, as a result of that, I lacked stability of housing. I bounced around from place to place. At one point, I was just a couple of weeks away from a homeless shelter. But thank God that Mercy College, which offered me a scholarship totally unsolicited, because it was mentioned in the Journal News, a human interest item associated with my case, that I had gotten the associate's degree. I got the GED before that. I completed a year towards the bachelor's. At the time, funding was cut for college education for prisoners, which I'd like to get a question on later. But I had 10 classes. I was 30 credits short. So they gave me the scholarship. And then when I lost the temporary housing I had, they allowed me to live on campus, and they gave me a meal plan. So that's how I avoided the shelter. But just to put in context, it was particularly hard for me to reintegrate because I had not had a driver's license. I had never gone shopping before. I had never lived alone. I never had to, write a check or balance a checkbook either. I missed births, deaths, weddings, rites of passage, finishing my education at a more traditional age, maybe being well established in a career, perhaps having a family. So all those things made everything really hard for me. It was somewhat of a lonely experience, I would say, after the psychological aspect. And, that was probably the second hardest thing, is because I was 32, but with a 32-year-old body, 17-year-old mind. I still want to throw a ball around and let's go to a carnival. I want to go on the bumper cars and, let's experience and try all these new things. And, but who are my peers to do that with? The people that are my age physically have been there and done that. They're in a totally different walk of life. I would have to go much younger, but then they're not going to have the maturity. So in some ways I'm younger than what I would be, but I'm also much older than, I understand the consequences and how something minor could speedball into something big, and it's a disaster. And somebody much younger, may not have that level of maturity. So there wasn't really quite a match there either. So it was very hard for me in that way. I was never able to obtain gainful employment. I was always, passed over for gainful employment, I would say. So I had this naive thought that I thought that since I was innocent and everyone realized that I was innocent, then people would, start me off at whatever level that I would have been had I been working my way up to that career, But yeah, so I mean, there were a couple of people in declining to employ me that said, well, we'd like to give you a job, but I don't want to have people protesting outside my store. Look, I don't know how my other employees are going to react. What if they walk out? I could run my business without you, but I can't run it without them. So, there was that aspect to it. I did catch on as a weekly columnist, but it was paying like $250 an article. But the issue was that they only wanted one article a week. I was making money doing speaking engagements, but that's not a consistent form of income. So it was a very, very difficult. It was hard to have money coming in. It was very difficult to say the least. But there were some bright spots, from like Mercy College to getting the master's, and law school and the foundation, but I guess those would be in follow-up questions.
Yeah, they will. And I'm actually going to limit myself because I want to make sure that the audience has a chance to ask their own questions. So I'm just going to wrap up my part of this by inviting you to tell us what you've done with your law degree and, creating the Deskovic Foundation and the nature of the work that you've been doing around wrongful convictions and systemic reform.
Sure. So I was an individual. So all that turmoil and difficulties that I mentioned, I was simultaneously doing advocacy work as an individual advocate for about 5 years, speaking, writing, trading privacy for awareness by doing, multimedia interviews, regularly meeting with the electeds, my school. Then I got some compensation and I wanted to take my advocacy work to the next level, which would involve freeing people. So I did decide to commit $1.5 million from the money that I got. And I started the Jeffrey Deskovic Foundation for Justice. And our missions are 3 R's. So reversal, reform, recovery. So what that means is, freeing people who are wrongfully imprisoned. We've been able to, we actually, the last 5 months have been kind of incredible for us. We've been able to free additional people. So we're at 10 now. We've been able to free 10 people. We have helped pass 3 laws, videotaping, interrogation, identification reform, DNA database expansion. I am part of the coalition group called It Could Happen to You, which I'm an advisory board member of, and which the foundation is part of. And so we co-brand and we do our policy work together. And we've been able to pass 3 additional laws here in New York. Commission on Prosecutor Conduct, tweak of that, discovery reform, which pertains to sharing information by the defense and prosecution automatically early in the process, rather than what was happening before, which was information was just being dumped on defense lawyers' desks on the eve of a hearing, on the eve of a trial, not even all the evidence, just pertaining to which witnesses the prosecution was going to call and if something was favorable. So we were able to pass those 3. We were so successful at that in New York that we were able to form chapters in Pennsylvania and California. So in terms of current initiatives, we're trying to repass that commission. DA's Association wanted no oversight, so they filed a lawsuit. They claimed it was unconstitutional. The judge rejected their arguments, but did find a problem in the appeal procedure. So the whole statute came down as being unconstitutional. So we're on the verge of repassing that. We did repass it in the assembly. We just got to get the Senate to pass it. So that would be the oversight for prosecutors. We're trying to get rid of the exceptions to the law that mandates videotaping interrogation. So right now, in homicide cases, sex offenses, drug cases, it's not mandatory. So we want to get rid of those exceptions. We're not spearheading, but we are playing an important supporting role with respect to parole reform, so that nature of the crime can't be cited as a sole factor. And then there's a elder parole piece also, in which anyone who's both 55 and has served 15 years would be eligible for a review, a consideration, not guaranteed release. So that's on our agenda in New York. We are pursuing 10 cases now that are active. In Pennsylvania, we were able to pass an automatic expungement bill. So we had the anomaly going on in our border state that people who were exonerated of crimes were nonetheless still have a record, which was impacting them when it came to apartment searching and applying for jobs. We were able to pass that. We're trying to pass the Commission on Prosecutor Conduct there. Pennsylvania is one of 15 states that does not offer compensation. So we've got the governor mentioning that as one of his priorities. So we've gotten that conversation going again. We have a chapter in California, which our goals there are to, we see an opportunity to kill the death penalty. So we're trying to take that and of course, the oversight for the prosecutors there. In terms of what I'm doing with the law degree now. So I'm doing things that I used to do before. I'm getting more opportunities of them. So I'm speaking more. I'm getting into some unusual quarters. So I've been able to address groups of judges on a bevy of legal topics pertaining to wrongful conviction. Same thing with respect to groups of prosecutors as well. I've been able to do some work with law enforcement as well, trying to get them to voluntarily implement best practices. The credential has helped my policy pursuits as an individual. I've endorsed in, I think it's up to like 15 different races where wrongful conviction and justice reform are part of the policy plank of the candidates. Maybe the endorsement I'm most proud of is, well, it would be a tie. So, I mean, I did endorse the Westchester DA, Mimi Rocco, who ran on a wrongful conviction prevention plank. But I also was able to endorse Yvonne Rosales, who for the 34th district in Texas, in Austin, she reached out and wanted my endorsement. So I thought that was, kind of flattering and a barometer of how far I've come. So there's those things. I've consulted some with and worked with elected officials in some other countries like Armenia and Argentina, but I'm also using the law degree. I've entered some of our cases now as co-counsel. In fact, before coming on this, I had a meeting with a senator, and before that, I was writing up this reply to the prosecution's reply on our Andre Brown case. So where it's in the Bronx. So in a nutshell, then I'll yield so we get the questions in. But Bronx DA is in effect holding our client beyond the reach of the court. So, he's been in for 22 years. He's been awarded an evidentiary hearing on his actual innocence claim, his newly discovered evidence claim, his ineffective assistance of counsel claim. Was awarded the evidentiary hearing a year ago, but hasn't been able to get into court because of the COVID, because the Bronx DA's office will not agree to do the hearing virtually. So now the issue is whether the judge has the authority to order the hearing to be virtually. And so where our position is yes, she's saying no. So I'm writing the reply brief on that one. So I am entered some of the cases as co-counsel, but I'm hoping to do like one or two cases as the lead. So, but I like the extra credential and the doors that it's opened for me. I've done a lot more media interviews. I think it adds an extra level of respect. So yeah, it's but a ton of work at the foundation, chasing donors and trying to get funding in the door, and it's approving cases or disapproving, and collaboration with the team. So I'm going to yield now, and I'm sure other stuff I would say will come out to questions.
That gives us an awful lot of different threads that the audience would be interested in tugging on. Let's see what they're interested in hearing more about.
And by the way, they can ask questions about anything that we covered, or even topics that we didn't cover. Could be legal, could be personal. I'm open book, so feel free.